Right, 27 November 2025, and today I'm excited to be giving you the evening update. And normally I only do this when there is something very important that would have happened. So today we've got a response from Mnangagwa, President Mnangagwa, and that is on the ED2030 constitutional court case that were filed against the resolution of the ZANU-PF, which was passed at Mutare. So if you go to Gambakwe.com, you can follow what I'm saying right now, which is a response that has been given by Mnangagwa. So what has happened is that the Attorney General of Zimbabwe, Virginia Mabiza, has produced a response for 3 people. That is the first respondent, the third respondent, and the 6th respondent. So I'm now going to share with you the screen so that you can see. So we had applied for direct access to the Constitutional Court, and Mabiza is saying that we are not supposed to get direct access to the Constitutional Court on the case where we are challenging Mnangagwa and basically all the people that are supposed to be upholding the Constitution. So you can see that the document says in the Constitutional Court case of Zimbabwe, case number CCZ4725, Moreprecision, Muzadzi, and pardon, Gambakwe. So that is the case. And the first respondent is President Mnangagwa. The third is the Justice Minister. And the 6th is the Attorney General. So Ziambi is not going to respond by himself. AG is going to respond from Mnangagwa and the Attorney General. So in their response, they've given a number of arguments. And as I said, you can go to Gambakwe.com. You hover over this document and a menu will appear at the bottom. And you can click through the document. So as you can see, this document has got 6 pages. The Speaker of Parliament has already responded. The Zimbabwe Electoral Commission has already responded. And now the other 3 respondents have already responded. So now everyone has responded, and we've got 10 days, in fact, 10 to 15 days in which to respond to the arguments that have been put here by filing what is called the actual main affidavit. So I don't know what this means now that we have an opposition to direct access. It means that this changes the whole thing. Remember, the Zimbabwe Electoral Commission said they are not opposing, and then we had an opposition by the Speaker of Parliament. So now let's look at this document. So I'm going to click back up here, and the argument that I'm making simply is that the case is not mature, so it is premature. Firstly, they're also making the argument that you cannot, so it's premature, and then you cannot sue the president without suing the political party. So let me read it so that you can get the points. I am the AG of Zimbabwe, and I've been cited as the 6th respondent in this matter. I dispose with this affidavit on my own behalf, and I've also been authorized by the 1st and the 3rd respondent to dispose to this affidavit on their behalf. The matters of fact which I depose to are true to the best of my knowledge and belief. And then let's go to what else she says here. I have read and understood the founding affidavit of the applicant and wish to respond as follows. Applicants allege that first respondent's political party adopted a resolution which effectively seeks to extend the first respondent's term of office. Such an extension, applicants allege, will violate applicants' political rights enshrined in Chapter 4 of the Constitution. To be granted direct access, applicants have to meet the requirements set out in both the Constitution and the Constitutional Court rules. Rule 26.4 of the Constitutional Court rules sets out the requirement for applicants of this matter. In the instant case, applicants have failed to meet those requirements, particularly how it is in the interest of justice that direct access can be granted. It is not enough for applicants to simply cite the provisions of Section 67 of the Constitution. And then further, applicants do not address the issue of potential disputes of facts and how such may be resolved. This is pertinent considering the allegations by the applicants that the resolutions were made by a political party which have not cited and is not before the court. Rule 26(9) of the Constitutional Court rules further sets out the factors to be taken into account in deciding whether it is in the interest of the justice that directs access be granted. In the instant case, the applicants have not addressed the issue of prospects of success of the intended substantive application. To start with, the attached draft of the substantive application is fatally defective. Applicants intend to bring the main application in terms of Section 67 of the Constitution. Section 67 of the Constitution deals with the political rights and does not entitle a person to approach this court seeking redress for alleged violation of rights. So I think you can clearly see what she's saying here. And then let's go to the last page. It says, further, the matter is not yet ripe for adjudication. The resolution has not yet been given legal effect. 2, nor has the legal process begun to make the resolution have the force of law through a constitutional amendment. The intended made application, therefore, has no realistic chance of succeeding. It is based on speculation and conjecture. It is not yet certain whether the constitutional amendment are going to be effected, and if they are, which provisions are to be amended and how the amendments are going to be implemented. This honorable court is therefore being asked to determine the constitutionality of a resolution made by a political party. It is also a requirement in terms of section of Rule 26 that applicants indicate whether or not the matter can be decided without the calling of evidence. Applicants in the present case have not bothered to engage with that requirement. Further, applicants have alternative remedies in the event that their issues considered to be right for adjudication. They can approach the High Court for the relief they seek. In the view of the above, it is therefore not in the interest of justice that leave for direct access be granted to the applicants. Wherefore, 1, 3, and 6 respondents pray for the dismissal of this application. So, I think you can clearly see what is happening. She is saying that she's raising technical issues. So, everything that she's raised are technical issues. So, as I'm not a lawyer, I'm not going to try and speak about law. But what I know, and what I know from ChatGPT, you know, Mazwano, everyone is a lawyer. So, these are technical issues, and the court can actually decide to proceed with direct access because the issues being raised, that is to do with the constitutional matter of extending term limits, they can overlook all the technicalities and proceed with this case. So this is what I believe is going to happen. I believe that this case is going to proceed because everything that has been raised is technical. For example, there is another court case, similar court case, which cites ZANU-PF. So if this one doesn't go through, there is also the one that has been raised by ZANU-PF. If this case does not do or does not have the necessary things that are required, the other case also has those. I hope that I'll be able to get that document and raise it with you. So Mnangagwa has responded. He's basically denying that he wants to change the constitution. And if he wants to change the constitution, he's denying that he wants to change things that are unconstitutional. Further, he is saying if it is found that this is not supposed to happen the way it is, we can always go to the High Court. So you can see that they are sending us back to the High Court, not to the Constitutional Court. Whereas these issues are Constitutional Court issues. If you're amending a constitution, a term limit, you are amending the constitution. That is why the Constitutional Court is there. So I think that you can understand. You can go to Gambakwe.com, and this is the story right at the top. We have also summarized for you everything that she's saying over here, so you can go and check it out. I don't want to take a lot of your time. Please go and look at the document. And then Senator Kalipani Pugeni, who is going to come and join me sometime this week to unpack everything that has happened. I'm also going to go and look for Advocate Ngube, and then we'll find out if he has received a response we have a very serious case before us. As you can see, Ziyambi did not appear as promised. We were promised this week that Ziyambi was going to appear by Mutsvangwa last week, but he has not appeared to speak about exactly what they're going to do. So this is why this case is important. Mutsvangwa said Ziyambi is going to come and explain what's going to get changed. But then this is all he said. So you saw what Ziyambi said this week. He didn't say anything we didn't know already. Let me see if I can find that video. Unfortunately, I can't find the video. I'll find the video tomorrow. But he basically says they are only going to extend the 7 years. They want to make a term 7 years, which is still a constitutional court matter. Okay. Right. I would like to thank all of you for watching, and I'll see you guys in the morning. I have to go and do more work, and a good night to you all.